you know the story? Tenants have 3
Yes.
months on a 3-year lease, or they've been there for 3 years now, but fear for their lives because of a shooting that happened. And do they have any recourse against management?
There's good news and there's bad news. The good news is that there is a law in North Carolina. It's called the Residential Rental Agreements Act that provides them with a series of rights that are really on point to their problem. One part of the act says that the premises have to be in a habitable condition. Habitable means you got to be able to live there. Now, obviously, if things are unsafe and people are getting shot out in front of your front door and there's gunfire and there's a security issue, that's not habitable. The other part of it is it says that the landlord's got to keep premises in a fit and habitable condition. It also says and requires that they have to keep common areas in safe condition. So the outside of the apartment door is common area where anybody in the apartment complex can go. So the landlord has a duty to keep the premises safe. And if there's violence or gunfire, they have to take action to remedy that situation, particularly if it's in an ongoing type of situation. And if they don't, they can have liability for that for sure. Now, what this means for the renter is that they could go into court and they could sue the landlord and say, you are not meeting the requirements of the Residential Rental Agreements Act, which you can Google and look at online. And based on the description, sounds like they would have a very good courtroom legal argument to make that the landlord's not abiding by the law. Now, the bad news. The bad news is that you don't get to not pay your rent while your lawsuit is going on against the landlord. So it's not as though you can move out and wash your hands of the situation and say, you guys are not providing me and my children with a safe environment, so I'm leaving and I'm not paying you anymore. That's not how it works. Unfortunately, they'd have to go to court and they would have to have that resolved by a judge or jury before they could be let out of the agreement. But the claim that they would make under the Residential Rental Agreements Act would not only be under the act, it would also be a breach of contract, the lease that they signed. In every contract like that, they have to, meaning the landlord, when I say they have to give you quiet enjoyment of the property and premises that you've leased. So obviously nobody's getting quiet enjoyment from their apartment if somebody's being shot or there's gunfire frequently, on the premises. So it would also be a breach of contract. And the breach on the part of the landlord would allow, if proven, the renter to get out of the remaining part of the lease. As you might know, none of this happens overnight. So given the time frame involved, I realize this is an imperfect situation. And as anybody that's ever intersected with the law is well aware of, the law takes a while to process through. So it's not a perfect solution for them. But what I would suggest is that if you go online and you look up the Residential Rental Agreements Act, you'll find the act or things that are written about it. Legal Aid of North Carolina also has a very nice write-up about the act and what your rights are and so on. And if they approach the management company and say, look, I know I've got these rights, I can sue you, I would rather work this out in a better way, then certainly the law provides the renter with some leverage with the management company to try and get the management company to work with them on this. Again, that's not perfect, but they do have the law on their side in this regard. And it's just that the law sometimes takes a while for you to bring the lawsuit and for the law to make a decision one way or the other about the liability.
Makes sense. And with 3 months left on their lease, it doesn't seem likely that it would
be a difficult situation. The other thing that I would suggest to the renters is that they take notes, that they memorialize what is happening. They write it on a piece of notebook paper. Today, I emailed the management company's office. I complained about this. And every time that there is a problem, they need to be documenting it and memorializing it. And then that could be used in court to show the efforts that the tenant went through to try and resolve the matter. And then it would also help them with proof in court about what had happened and the attempts to rectify and solve the problem. And so I would really recommend that they keep a good record and make a record. Email the management company is what I would suggest, rather than just making a phone call. So they've got it documented. Documentation in the law is very important. And I would suggest to the renters, the tenants, that they do that.